Welcome back to the Constitutional Clarion. I've had a few questions from the media recently about whether Julian Assange, when he returns to Australia, could run for the Australian Senate. So this is just a quick video about that. You might remember that Julian Assange actually did run for the Australian Senate in 2013 when he was holed up in the Ecuadorian Embassy in London. Now, this was apparently based on the belief, probably more fantasy than reality, that the United States and the United Kingdom would stop pursuing him if he were an elected member of the Australian Parliament. At the time, I was also asked by the media about his qualification to run for Parliament. The issue then was that he hadn't actually resided in Australia for so long that he had lost his right to vote in Australian elections. There was a complicated question about whether he was entitled to nominate for Parliament on the basis that he was qualified to be on the electoral roll, even though he actually wasn't on the electoral roll. There was also a question about whether his acceptance of asylum in the Ecuadorian Embassy amounted to him being, quote, entitled to the rights or privileges of a citizen of a foreign power, unquote, contrary to section 44(1) of the Commonwealth Constitution. Nonetheless, Assange's nomination was accepted by the Electoral Commission because the Electoral Commission actually has no power to determine the validity of a nomination. That's a matter later left for the courts if someone challenges. Assange established the WikiLeaks party in 2013 to support his candidacy for the Senate. It espoused libertarian principles such as opposition to compulsory vaccination, presumably in order to attract the support of the anti-vax community. Assange apparently intended, once elected, to be able to use parliamentary privilege to be able to leak, publish confidential information while avoiding prosecution because of freedom of speech in the Parliament. The WikiLeaks party ran candidates in Victoria, New South Wales and Western Australia, with Assange himself heading the ticket in Victoria. All its candidates failed to be elected and none of them even obtained the return of their deposit because they didn't reach the threshold of 4% of first preference votes. Assange secured a little over 1% of the primary vote in Victoria, with the other candidates in the other states doing worse. The WikiLeaks party fell apart due to internal fighting over preference deals, candidate resignation, and of course poor internal party management that it was claimed did not match its platform of support for transparency and accountability. It was eventually deregistered in 2015 for failure to maintain a sufficient number of members. So could Assange now run for the Senate at the next election? Assuming that he decides to reside in Australia and he gets back on the electoral roll, the question would then be whether he was subject to any kind of disqualification in the Constitution. What the media keeps asking me is whether his conviction in the United States of a felony of conspiracy to obtain and disclose US national defence information would disqualify him from sitting in the Commonwealth Parliament. Section 44(2) of the Constitution says, any person who is attainted of treason or has been convicted and is under sentence or subject to be sentenced for any offence punishable under the law of the Commonwealth or of a state by imprisonment for 1 year or longer shall be incapable of being chosen or of sitting as a senator or a member of the House of Representatives. The first question is whether this actually extends to foreign convictions. It refers specifically to offences, quote, punishable under the law of the Commonwealth or of a state by imprisonment for 1 year or longer, unquote. On its face, this is a little ambiguous. It doesn't explicitly state that the conviction has to be under the Commonwealth or state law. Theoretically, an offence of murder, for which a person was convicted overseas, would also be an offence punishable under a law of an Australian state. But given that there's a presumption against extraterritoriality, and the provision does refer to offences punishable under Commonwealth and state laws, it's reasonable to assume that the disqualification does not extend to foreign convictions. Of course, ultimately it's a matter for the High Court to interpret the Constitution, and so far there have been no cases on that particular point. As for that word punishable, why is it there? Well, it's actually used in that provision to indicate that it's not the actual sentence given to the person that counts when you're looking at whether or not it extends beyond 1 year. It's how serious the nature of the offence is, judged by reference to whether a person convicted of it could have been punished by imprisonment for a term of 1 year or longer. In any case, the other critical aspect of the disqualification is that it only applies to a person who is still under sentence. That is, they are still serving their sentence, or to a person who has been convicted but not yet sentenced, as was the case with Rodney Cullerton, one of the few cases that actually deal with this provision. People who have previously been convicted of an offence and have served their sentence are not disqualified from being elected to the Parliament in Australia, unlike the position in some other countries. So could Assange stand for Parliament at the next election? It would seem that his conviction in the United States and his previous conviction in the United Kingdom concerning his bail breach would not be an impediment. But he would also have to be careful about the other disqualifications in Section 44, as indeed all prospective members of Parliament should be, because as we know, for example, the dual citizenship disqualification did manage to trip up quite a number of wannabe politicians some years ago. Thank you for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.